licensing board. We're the actual board or agency, if you like, that regulates the practice of brokering in the Commonwealth of Massachusetts. And what that means is that we are the folks that actually license you and all that goes into licensing you, including education and examination. And we're also the folks that, if need be, we hope that doesn't happen often, discipline you for violations of the relevant statutes and regulations that govern your practice. And also you probably should know that there is the actual board, the members who are appointed by the governor for a term of 5 years and can be reappointed, that come in periodically to meet. And then there's the day-to-day board, the office staff and myself that are carrying out the board's business on a day-to-day basis. The most common question we get from consumers is whether or not someone is licensed, as you might expect as a licensing board. And so that's relatively easy to answer because, like anybody else, we have access to the database, which, by the way, is the official record. I sometimes have to chuckle because while the card that we mail to you, of course, is important, the card is really just representation of this whole concept or idea of licensing, and that's what it is. Licensing is a concept, and the actual record of the board, if you will, that you see on the web showing who is licensed is the actual representation of this concept of licensure. From real estate agents, questions we often get have to do with whether or not they can share in their valuable consideration with out-of-state real estate agents, which of course they can. Those are agents who are duly licensed in other states, and whether they can share that with consumers. And the bottom line answer to that is generally brokers cannot share in their valuable considerations with people who are doing brokering and don't hold a license to do such. But the one exception to that would be the principals in a transaction. In other words, if you're someone who's listing with a broker and you're going to represent that person as the agent, you're going to be an agent for them and they're the seller, or if you're producing a buyer who's going to buy a house that you already have listed, you can share in your consideration with the seller or the buyer because they're the principals in the transaction and they don't need to hold a license in the first place. The complaints don't change, strangely enough, notwithstanding the ups and downs of the economy. The overwhelming majority of complaints, I mean it's well in excess of 90–95%, are deposit disputes. That's when a transaction, typically a purchase and sale transaction, does not come to fruition, and both the seller and the buyer want the money. And on top of that, the parties, the sellers and the buyers, will have signed a purchase and sale agreement. Often they're the standard agreements that are made by the trade associations, and they're fine, but they'll have a deposit dispute clause that says that if competing claims are made to the broker for the money, meaning a claim by the buyer and a claim by the seller for the deposit, that the broker has to hold that money until the buyer and the seller come to some sort of resolution amongst themselves and instruct the broker with what to do with it. And while the licensing law basically says a broker shall account for and remit money that's come into his or her possession, and you could argue that a dispute over the deposit is just that, and it is, the fact that there's a contractual clause in the P&S is going to trump that. In other words, the licensing law is the law, but we don't regulate what the parties, being the sellers and buyers, agree to. And so if they've agreed to that, and there's a clause in an agreement like a P&S that has that, then a broker is going to be bound by their resolution. And sometimes that can take a long time, and we'll still try to intervene to help, but there's really not a whole lot we can do when those clauses exist. And it's not about whether they're good or bad, it's just that that's what the parties have agreed to. That's the typical. When the economy sometimes is tougher, we will see a slight spike in escrow problems. And what that means is it's taking brokers longer to remit money, or those escrow funds are not fully capitalized. In other words, they're writing checks that bounce. That's an immediate problem for the real estate board. And that's one of the most serious potential violations, which is an escrow. Because there should never be a situation where an escrow check bounces, because that's not the broker's money. That's money being held for other people. So money's always coming in and going out, but there should never be a situation where a check bounces. What that means is that escrow account doesn't have sufficient funds in. That begs the question, where have those funds gone? And often, they may be used in a challenging economy for business expenses, which is a clear violation of the licensing law, since brokers should never mix their personal or business funds with escrow funds.